All right. Well, good afternoon and welcome to the No Cap Sports Podcast. I'm your host, Will Baggett, here on with some exciting guests today to talk about a much needed topic, one that is in some ways gone overlooked in the NIL space. Talking about the international student athletes and their ability to profit off their name, image, and likeness. So today we're going to talk to some exciting guests to kind of educate you on this group and what opportunities they have and how we can get there to make sure they're included in this groundbreaking legislation. All right, let's get started. And Jonathan, I'm going to start with you. And welcome to the show. And if you would introduce yourself and just let our audience know what we're going to be talking about today.
Hi, my name is Jonathan Grode. I'm the managing partner of Green and Spiegel. We're an immigration firm with offices in Canada and the United States. And we do a lot of sports stuff, but it's been very traditional, Will. Like professional athletes, individuals coming to compete in international competitions.
Mhm.
And what's exciting about today's discussion is we're really pointing towards what I would say is like sort of the wild west of immigration law. It's uncharted territory. We're forging our own path. And there's a lot of things that are uncertain. And what's fascinating, and I think we're going to get into this in a little bit more detail, but really what you have here is a decision by Congress that's changed the way that students can function in terms of their likeness and profitability, as you mentioned. But immigration, which is like a cruise ship, is going to take a long time to turn and adjust to these changes. And now, what do you do in that interim period? And trying to figure out what you can and can't do is, as geeky as it sounds, kind of exciting stuff for me and my colleagues. So I think that's my little opening salvo for us today.
Very nice. Thank you so much, Jonathan, for joining us. And I look forward to your insight today. I'm going to come to you, Kiznia, and talking about current visa options for international student athletes. I know you wrote an article on that subject matter. So if you kind of talk to us a little bit more about that, we'd love to learn from you.
Sure. So my name is Ksenia Mayorva. I'm the managing partner of Mayorva Law. We're a firm that's focused on sports immigration. We work with a lot of Olympic caliber athletes, but also a lot of athletes who are sort of transitioning from NCAA competition into the professional ranks. So about 80% of the athletes that I represent are track and field athletes who compete in NCAA and are transitioning over to P visas and various other sports visas. And the NCAA for track is a very high level of competition because the same people that you see line up at NCAA national championships are the same people that you see line up at world championships and the same people that you see line up at the Olympics. So it's a really exciting space to function in, but it's a space, like Jonathan said, that has now sort of been turned on its head with a lot of new rules that we now have to consider. And, I'm certain that the folks that had the NIL agenda in mind totally didn't think about the immigration implications of this. And I think one of the things that we will be talking about today is the ways in which student athletes from countries other than the US, so those who are not citizens or lawful permanent residents, are really limited in their abilities to fully take advantage of NIL opportunities because of immigration limitations and because of the existing framework of immigration law that puts significant limits on what we consider employment.
Absolutely. Thank you so much for your wonderful insight and looking forward to hearing more about that. Coming to our third guest, if you could kind of share with us, what your insight is on immigration laws for international student athletes.
Okay. Hi, my name is Shahana Farishta. I'm an associate attorney at Green and Spiegel. And when I was contacted by No Cap Sports, I was very excited for this opportunity to help because this is uncharted territory. And I'm actually a newly barred in associate, and I was barred in January. And I was so interested in changing the legal framework of the law in immigration, aside from just practicing it, because I feel like attorneys have the specialized knowledge to be able to effect change and lobby in a way that other specialized people don't have knowledge to do so. So this was my chance to be able to create a framework to be able to allow these international athletes to be able to take advantage of these new laws sooner than later.
Absolutely. Thank you so much for your insight on that. And Jonathan, I want to come back to you really quickly, and I want our other guests to chime in as well. But talk to us about the current landscape. And you guys have hit on it a little bit. You've kind of mentioned it in passing. But as we sit right now, what options do international student athletes on F1 visas have in terms of passive income, CPT, on-campus employment? Can you talk a little bit about that, please?
Yeah. So when you're a student in the United States, just like you get a visa, most often it's F1. That's what like 95% of your student athletes are on. And with an F1 visa, you're not really meant to work.
Mhm.
There's a provision that says you can work up to 20 hours a week on campus whilst you're in school, and then during breaks you can work 40 hours a week on campus. So like over Christmas or over the summers, you want to go work at the convenience store, that's cool. You want to go work as the equipment manager, that's cool. You want to be at the tennis facility checking people in and out. Like it's supposed to be incidentary work, essentially. That's what's automatically permitted with an F1 visa. Then you have something called CPT, which stands for Curricular Practical Training. And that's allow you to gain experience in an activity related to your major field of study whilst you're in school. So Will, you're a chemical engineer, you know, you're a foreign national, you're getting a chemical engineering degree. There's a chemical engineering company that wants to hire you to get you some practical experience. You can go to your designated school officer. You can ask for permission to work. They sign the back of Form I-20 and you're off to the races. And there's sort of the rules from USCIS and Department of Homeland Security regulations that are the floor, saying this is pretty much permissible as long as it's related. And then schools have their own regulations that kind of go on top of it. And some are really, really strict and saying you can only get CPT if it's leading to credit. And others are like, man, we don't care. Go ahead and do it as long as it's related. Here's the rub as far as CBT goes and NIL stuff, and frankly, student athletes working, is the work for CPT has to be related to your degree. Nobody majors in being an athlete. You don't major in track and field. You don't major in volleyball. You're majoring in business administration, communications, science, whatever it is. So by its very nature, CPT is challenging to get authorization to do things related to sports activities. So before we even get to OPT, let's digest that a little bit, okay? You're allowed to work 20 hours a week on campus. Okay, well, maybe through the NIL program and being able to earn income, you want to set up like a camp for local high school students. If it's occurring on campus, there's an interpretation that says it's okay because it's on campus. But if you wanted to go and do it at a local sports facility and you wanted to get them to sponsor you for CPT, the school is most likely going to say no. And that's where this disconnect lies. Now, will USCIS and Department of Homeland Security move to change their regulations in light of this Supreme Court decision? The jury is sort of out at this point. I would like to think, at Ksenia, I don't know if your feelings are, but I feel like they have to do something.
Mhm.
But, you know, what are the chances of them doing something now? I mean, look at what's going on in the world. We got a pandemic that refuses to go away. We got an infrastructure bill that, you know, just resulted in they kicked the can down the road. I think I just read till December 3rd or something like that. We got humanitarian crisis at the southern border. We got Afghani refugees coming in. I think this is an important issue. And it's certainly important to me as somebody that does a lot of sports visas. It's certainly important to Ksenia, it's important to Shahana and you guys. But is this top of mind for the agency? Probably not. Probably not. So where does that leave us? And here's the thing about student status. You got to protect it. You got to hold on to it. And sure, everybody wants to work and make money and take advantage of these things. But is it worth jeopardizing your ability to remain in the United States as a student? Who wants to push the envelope when the consequences are so severe? You know, some designated school officials, those are the guys that control your I-20s, and they use this record called CVIS, which like is your electronic eligibility. If they think you violated your status, they will cancel your CVIS record. You are out of status. And then you have to seek either a reinstatement, depart the United States and try to get a visa abroad and come back in. You miss a semester, you miss a season of playing whatever sport you're trying to play. And are those consequences really worth it to be able to promote the local car dealership? So I think everybody has to have a dose of common sense. And before I hand it over to Ksenia for her opinion, I think when it comes to the law, there's almost two schools of thought. And that is, should I ask for permission or should I ask for forgiveness, right? This is one of those instances where you want to ask for permission. Like, I'm a big believer, I'm a permission asker by nature, but I cannot say, and I cannot emphasize enough that this is an ask for permission situation. Don't listen to the guy who's offering you the money. Don't listen to the booster. Go to your designated school official. Go to your International Student and Scholars Office. That's what they're there for. They are there to help you navigate this system. Hire an immigration attorney. If your goal is to be professional in track and field, Ksenia is the best in the business. She'll take your call all day. So I think that's sort of the messaging that I want to get across is, until we know, don't assume. Don't say this has to be okay. Don't say, oh my God, all my friends who are Americans are doing this. I should be able to do this, because you're not permitted. And I think that that's really the critical part. And I'm happy to talk a little bit about OPT and what that means. But Ksenia, I don't know if you concur, disagree, what your feelings are.
I'm completely with you. I think this is a situation where you ask permission, and the reason why is because there's sort of two broad avenues of immigration to the U.S. Well, actually, there's more, but 90% of people will either go through the employment-based track or the family-based track. And the family-based track is much more forgiving. There are waivers, there are, types of forgiveness that you can get based on relationships to U.S. citizens that you would innately have because you're on the family track. The employment-based track, which is where most athletes are going to go, is far less forgiving. And most of those people don't have the qualifying relatives to get the waivers, right? To the extent that they do violate something. So in many cases, for a person heading down that employment-based track, so they're on the trajectory from a student visa to potentially a sports visa to a green card down the road, we really have to be careful about maintaining status, not violating status, and not taking part in any activities that could be construed as violating status. Because Jonathan is right, the landscape is not clear, right? And we sort of talked about this before. It's a matter of how do you define employment, right? And neither immigration law nor labor law defines the concept of employment. And in many ways, it's a spectrum of things that we know are definitely permissible and things that we know are definitely not permissible. But I would almost go a step further than what Jonathan said when he said, go to your DSO, because I feel like even with DSOs, it's a patchy framework of policies. Different schools will tell you different things. Different DSOs at the same school will tell you different things. And I think if you really want the protection, you really need to go speak to an immigration attorney, because oftentimes my position is going to be more conservative than that of the DSO. I'm going to tell my athlete, look, I really don't want you doing this because my plan for you doesn't contemplate, us having complications from the possibility of this being construed as an authorized activity. So, so we have to get to a place where the DSOs are giving consistent information, which I think requires the framework, right? But we also, in the meantime, would defer to legal counsel.
And I agree with you there. I think what I'm trying to point out is, like, the DSO has so much power when it comes to student status because they maintain the SEVIS record.
Sure.
And that to me is like, keeping that active and valid is like your initial most critical step. But Ksenia is right. Like, down the road, when you're going to apply for your O1 visa or your P1 visa, a USCIS officer might not agree with what the DSO had said. And that is a very valid point. And that is where counsel does play a key role. So I appreciate that clarification. It's one of these things where it's a little bit difficult if you're not intimately familiar with the F student visa realm to like understand the different players here. So just to kind of frame it out for the listeners, the designated school official, that's who we're calling the DSO. They're the ones that sign off on your Form I-20. When you're a foreign student, you get that Form I-20, you go to the embassy or consulate, you hand that in, they put the visa in your passport, and then you're off to the races. Once you're inside the United States, the DSO is the one that authorizes CPT, which authorizes the OPT, and who maintains the CVIS record, which is the electronic interface between the school and the Department of Homeland Security. So they're almost like this gatekeeper of your status. So they have the ability to take it away, and they have the ability to authorize work. But Ksenia is 100% correct in that just because the DSO says it's cool today doesn't necessarily mean an immigration officer down the road is going to concur. So the consequences are heavy. And I think that's like the ultimate message that we're trying to get across.
Absolutely. Wow. Shahana, anything to add?
I actually have a question. So as a baby attorney, I might be a bit idealistic, and Jonathan mentioned that it might be a priority for us to want to make these changes, but it's not for the agency. But in the past, like as students, we were able to get media attention for a detainee who was not a priority for the agency. And after getting an article published on Wall Street Journal and having Elizabeth Warren and everyone share that everywhere, we were able to pressure the agency into one, noticing that 14-year-old detainee and then pressure them to release them. So I feel like, what can we do in this sense to get that attention and make it a priority for them?
It's a great question.
Well, that's where your organization comes into play, Will. I mean, that's exactly what you guys are doing. They're gathering up all the DSOs. They're trying to create a coalition of people who want to raise this as a serious issue. Absolutely. And Shahana, you're right. It's funny. I always say there's most of the time with immigration, you don't want to highlight attention to your clients. Nobody wants to like make a big deal about the fact that they're getting a visa, that they're going through something, right? There's some instances where you want to scream it from the rooftops, where you want to get as much attention as possible. And that's why I think having an organization dedicated to this particular issue who cares about foreign students is going to be critical in fostering change sooner rather than later. But again, Shahana, this is a very odd time in the world. And I think striking the right chord with the right momentum is an incredible challenge.
I would agree with that. I mean, I think it's challenging from the immigration law perspective because our membership association, the American Immigration Lawyers Association, is typically focused on issues that are more humanitarian in nature, right? The things that the media is willing to talk about, the things that are interesting, the things that strike an emotional chord. This is probably not something that strikes an emotional chord in the way that 3-year-olds testifying in court without counsel and being forced to explain their reason for seeking asylum. So this is a vastly different type of issue. So I think Jonathan is right in that a coalition needs to be built among DSOs, among foreign student athletes, among coaches, among compliance officers at NCAA schools to actually bring this issue to the forefront. And in many ways, actually, I think it does have the ability to be more of an issue that bridges, what we see as divisive politics right now, because humanitarian issues, I'll be honest with you, I've been going to lobbying days for the American Immigration Lawyers Association for the last decade on and off. And when you go into certain offices and you talk about the detention conditions and people at the southern border, you essentially hit a brick wall. These people don't care, right? These are not issues that are important to their electorate, so they're not important to that congressman or to that senator. Whereas I think that there are issues that are not as politically divisive, and this issue has the potential to be that type of issue. Because it's not humanitarian, it's not going to get as much media attention, but it could get a lot more ears from the right type of people who are involved in the key decision-making activities and the legislative activities that can get us the framework that we need for the student athletes to be able to participate meaningfully and on par with their U.S. counterparts.
No question. Thank you for your insight on that. I definitely learned a lot and some new acronyms today that I wasn't aware of. But yeah, as we work through with the DSOs and with different campus officials, and you guys kind of hinted at it a little bit, but what can international student athletes kind of do in the interim? How do we help? How do they help us help them in a sense? As far as working with the DSOs and what questions to ask. And you mentioned having to ask for permission as opposed to forgiveness. So specifically, what kind of questions should they be asking to kind of elaborate on that point?
I think that they really need to be speaking to council about the possibility of transitioning to O and P visas to the extent that they might be eligible. So just because you're in college does not mean that you would not be eligible for an O or P visa. I do these visas for athletes who are still in college to the extent that they're sufficiently internationally recognized and accomplished. And those visas have a lot more latitude in terms of authorized activities. So a lot of the NIL activities would be non-controversial to the extent that they were properly included in the structuring of an O or P petition for that athlete, right? And the O or P would still permit the athlete to attend an NCAA school as a student athlete. So there's no issue with that. ICE has a chart that says who can study, and so O's and P's can do a full course of study. There's no issue with that. There may be some amateurism issues, and I think that that's sort of outside the realm of what we do as immigration attorneys. And to what extent does somebody who goes to an O or a P and now has NIL stuff plus potentially I don't know, a Nike shoe contract, how does that implicate their right to continue to compete as an amateur within the NCAA structure? I don't have the answer to that. That's not exactly my area of expertise. I don't know if Jonathan knows the answer to that. But my first piece of advice would be see if you can go to something other than an F that'll give you more opportunities, right? And if you are on an F, you need to talk about what are the limitations of what you can do right now, given the landscape that exists today. Because we don't want to be aspirational about, okay, well, we could ask Congress to change the F1 visa regulations to specifically include NIL, or we could ask the agency to provide a policy memorandum where they expand the concept of on-campus employment to include NIL activities, even if they physically occur off campus, right? So those are all things that we could aspirationally hope for, but those are not things that exist today. And, and that means that the athletes that are in the system today have to work with the system that exists for them as of right now and have to be very careful about compliance. And Jonathan, you had something to add?
Oh, I always have something to say, Ksenia. I actually agree with you wholeheartedly. I think it's a lot easier to go into an O1 or a P for individual athletes than it is for team sports players.
Yep.
Like it's really, really, really challenging if you're still in university and you're playing a team sport like basketball, soccer, hockey, and that kind of thing to hold yourself out as an O1 because you can't really do it otherwise. And the P can be challenging because you don't have individual competitions.
Yeah.
So it doesn't work for everybody, but it's certainly something that should be in your thought process and how you try to diagnose a situation. I also would say check out the terms and conditions of your scholarships. Because if you are getting a scholarship as an athlete, not saying that this is going to be an issue switching to O or P, but some of them are contingent on maintaining amateur status, as Ksenia kind of hit it on, or some of them are tied to school visa sponsorship, or the school might impose its own regulations because, to be an F1, you have to be a full-time student. If you're on an O or a P, you can go part-time, but your scholarship might be associated with your status. So it's a kind of a weird sort of thing. To get an O or a P, you might have to be doing more professional type of activities, which would take away your ability to be a full-time student, which could impact any financial contributions that you're getting for the university towards your education. It's my way of saying it, there's no panacea to this situation right now, Will. And I think it's disheartening sometimes to hear from a lawyer that says, I don't have the answer. I don't know all of the answers, but good lawyers are willing to say that. We're willing to say, we don't really know, but we can assess your risk. And these are the things that you should be considering. And that's why Ksenia and I have had the pleasure most recently, quite regularly, to cross paths and talk about issues. And that the way she approaches problems is very pragmatic. And that advice is indicative of, what we're saying. There might be other options for you, but just because there is an option doesn't mean it is the best option for your situation.
Mhm.
And you can't just look at it and say, I want to go and put my face on a billboard for this and this and that. It has to be, if I do this, what are the consequences? If I do this, how does it affect my ability to be a student? How does it affect my ability to get drafted? How does it affect my ability to get a future working visa? And that's what's exciting about this time, and also really daunting, And that's why, getting back to Shahana's point, the right balance of advocacy to kind of push things along so that we have a more definitive landscape is critically important. Will, I don't know if you want to circle back to it because I never fully answered your question before, but you want a little bit on OPT, or should we move on?
Let's try to take the next question, and that may come back up in the next part of our discussion. I wanted to kind of talk about why this matters so much, and we kind of hit it on a little bit there. When we talk about the impact to the schools, community, and things like that, why is it so important? And I find it interesting that with NIL is so unregulated, for American student athletes, but when it comes to international side of it, they can't hardly do anything, right? So it's just a really, weird juxtaposition. So when it comes to the international community, and you think about some international sports being even bigger than American sports in that regard, talk about why this matters, financial impact and otherwise, in your regard.
I mean, for all the reasons that it's important to American students, it's important to international students. And Will, you hit a really good point. If you're well known within your home country, we'll take my most disgruntled yet still favorite basketball player, Ben Simmons. When he was coming out of Australia and going to LSU, that dude could have signed millions and millions and millions of dollars of NILs for companies in Australia. Nothing to even do with the United States, even though he probably could have gotten some bank here too. But just purely in Australia. So you take that example. Currently, the regulations don't let you do it.
Mhm.
Even with the permission to have your likeness taken, even if the money's earned overseas, because our laws, our tax system is worldwide taxation. If you are working, it doesn't matter where you are working. Now, that's partially because most of the immigration laws of the United States were written in 1986 and 1996, before we even had a concept of remote work and remote generation of income. But here we are 25 years later, and that's what we're stuck with. So the financial implication is huge. And, frankly, I mean, you probably know the statistics better than I do, but so many people with aspirations of playing professional ball don't make it out of college because of injury, because of academic issues. They don't have that chance to get that payday. And insurances that you can purchase sometimes are untenable from a premium rate for some families. So, to have that financial fortitude and finally get a share of what the universities, and I think this is what the Supreme Court's saying, look, you're making money off of these people. They should be able to make some money off of you.
Mhm.
And that financial wherewithal is critically important. The rub is, and I say this to foreign nationals regardless of what they're doing, you are not American. When I talk to somebody who's an entrepreneur, I tell them, you can't beat Bill Gates in your garage building a Windows PC. You can't let things happen organically.
Mm-hmm.
You have to be very intentional with all of your actions. You have to be pragmatic with your status as it relates to your future career.
Mm-hmm.
You are forced to think about the future as a foreign national more so than an American. And that's the challenging part. Because at that age, when you're with your peers and everybody's doing all these things and they're taking these opportunities that they come and they're just luckily going through college life, you cannot do that as a foreign national. You have to protect that status and hold on to it so dearly, because the future consequences are very, very, very significant. So it does matter. the financial aspects of it are huge for some individuals. Huge. But I don't think you can yet take advantage of it in the same way. Ksenia, I don't know if it's like
Yeah,
you deal with more individuals. So just so the audience knows, like I deal with more team sports people and like leagues and stuff like Ksenia. This is why we're a good pairing for today, because Ksenia does with a lot more on the individual front. I maybe you have a little bit of a different take on it.
I mean, I think everything you said was true. I think from, the financial impact, another angle on this is that I work with athletes who participate primarily in individual Olympic sports, right? So again, my track and field athletes. Many will be surprised to learn that professional track and field athletes in most events, other than sprints and a handful of others, make less than $10,000 a year from the sport. So we're talking about people who are out there lining up at the Olympic finals that are making that little money, right? So these are people that are not paid a living wage for what is effectively a full-time job, because they train Monday through Friday. They have they're on the track in the morning from 9 until 12, from 12 until 4 they're in the weight room, massages and all that stuff, right? So we have a lot of people who are undercompensated for the work that they do. And what NIL lets these athletes tap into even before they go pro, is microeconomies, micro sponsorships. And that's amazing, because what it means is an athlete who is not quite yet there to sign a shoe contract with Nike for $100,000 can go stack micro sponsorships. They can go to this pizzeria and said, hey, why don't you pay me $2,000 and I'm going to stand at your pizza shop every weekend wearing my Tennessee Volunteers uniform. I'm a Vol, by the way, go Vols. So, I'm going to stand out here wearing my Tennessee Volunteers uniform and promote your business. I'm going to go to the local dealership and, Ford dealership, I'm going to help you sell your Ford trucks on Labor Day, your biggest sale day of the year. I'm going to stand out there in my uniform and sign autographs because I've been to the Olympics, and that's an opportunity for them to have a living wage for what it is that they do. And so many people don't think about these athletes and their financial situations and the way that they struggle financially. And the reality of it is, many are on scholarships, but many are not. And many universities really survive off of international student tuition and fees, which are 3 to 4 times higher than they are for in-state students. So, this is a win-win situation all around, because it's a win for the university. They get their tuition money, for example, right? If it's somebody who's not on full scholarship, it's a win for the local community, because these micro businesses can now take advantage of working with high-profile athletes. They're promoting their pizza, they're promoting their car dealership, and it's a win for them. It's a win for the students, because look, I don't know, this probably ages me somewhat, but when I was an undergrad, minimum wage was $5.15 an hour, so I was broke. Look, it was a difficult time, and these athletes stand the opportunity to go out there in the community and make money. Why is that a bad thing? And again, and that promotes the brand of the university, because in many ways, they're not just selling their own name, image, and likeness, right? Their name, image, and likeness was made through association with the brand of the university that they represent. And as we know, transfers are relatively uncommon, right, at the collegiate level. So we have some, but it's not like, it's not like at the professional level where somebody could be playing for a different team every year. So, it's great for everyone. So I feel like the financial benefit really spans so many stakeholders that probably haven't even thought about the ways in which they could benefit from all of this, which is why it's important to talk to these stakeholders and explain to them, this is what you stand to gain from this financially, reputationally, and this is why you need to be involved in this lobby effort to get the rules changed so that athletes from other countries can participate in these programs without fear of violating their status and jeopardizing their own immigration future.
Oh, Will, you're muted.
Yeah, thank you so much. Yeah, Sean, I want to come to you and see if you had, any thoughts on the conversation.
Yeah, I think I really agree with Ksenia's point because even though this is, like Jonathan said, you are not an American. You can't say that this is what you want and you're going to have that same privilege that these Americans have. But even though this is not emotionally appealing, it is an important, like it's fiscally appealing to people who are stakeholders in this to go to them and be like, this is the money you're losing out on, and lobbying that point to them because that's going to affect change. Because when I was an immigrant here, I came as an L2 dependent, and my parents as attorneys sat me down and they were like, you're going to want to go to parties and like do underage drinking, go shoplifting to rebel against your parents, but don't do that because you can't. And that was frustrating because I was a rebellious child. I wanted to do
everybody wants to
intoxicating
go
crazy things.
shoplifting.
No, not that, but other things. I was able to do so much, and anytime there was anything involved in a party when I was underage, I would leave right away because I didn't want to be caught in that mess because it would be very bad consequences for me compared to other people. But as Jonathan said, I had to focus on my future, which was to be a lawful citizen. So when a time came for me to be able to be naturalized, which I am a naturalized citizen now, I'm able to do anything I want. So I think it is a good balance between understanding the future consequences, but at the same time, asking for what you want, because what you're demanding is a win-win situation financially for everyone involved, including you. So why not present that idea to the right people who are also financially benefiting from that?
I'd like to take this opportunity to offer free legal advice. If you're an immigrant, even in a state where weed is legal, do not smoke weed. It's still legal under federal law, and you will get deported and forever banned from the United States. So that's your freebie for the day.
Right, we appreciate that.
What's the exception? 30 grams for personal use. Let's not get into that.
Yeah.
Just don't smoke weed. Okay?
It is 30 grams, yeah.
There's
No drugs. Very nice. John, we'll come back to you as well. Kind of the last part of our conversation, kind of talking about the OPT piece and any other kind of thoughts you want to offer, in terms of this conversation.
So OPT functions similarly to CPT in that it's optional practical training. So curricular practical training, CPT, while you're in school, OPT, optional practical training. And the idea is for most majors, and there's some exemptions where you can get more than 1 year, but for most majors, you get 1 year of work authorization after you graduate. And everybody thinks that it's this ubiquitous thing where you can go and work wherever you want. It's not, Will. It's not. And that's where people get caught up because it has to be related to your major field of study. So taking my chemical engineering example from earlier, you can't graduate with a degree in chemical engineering and then go on the volleyball tour for a year and get paid and say that that's cool because it's not related. So it has to be related to your field of study. That's the one where I think for athletes, you could see like a big carve out coming. Because Ksenia, I see this with some of the sports that you're not always going to qualify for an O&P right away. Just like we were talking about how some people qualify for an O&P while they're in school, some people don't qualify right after graduation until they get a little bit into their profession.
Sure.
So seeing an expanding of that, a little bit more of a carve out or a policy memorandum on allowing student athletes to engage in their major or their sport of choice, I think would be a simple solution to a lot of that post-graduation anxiety regarding status. Now, you can also get OPT while you're in school. It's called pre-completion OPT. It's something you apply for. The application process is so long right now. The government is so backed up. It doesn't really come into play very often at the moment. But again, same standards, same related to major, same qualifications apply. And you just got to be really mindful of the fact that just because you have a card that says you can work, just because you have a card that you can present to an employer and that they will satisfy the I-9 requirements to show that you're eligible to work in the United States does not mean that you're acting within the bounds of the regulation. And that's a tough thing to get your head around if you're not like really sophisticated into the law. You have a card that says I can do it, but you really can't. And you got to be a really, really careful there. But again, if we're going to Congress, if we're going to the Department of Homeland Security, if we're asking for them to engage in some level of understanding that there's a changing landscape for students, not only looking at names, images, and likenesses, not only looking at the ability to engage in activities related to your field of athletic prowess whilst you're in school is important. It's important to also say what happens after graduation. How can we facilitate this transition from amateur athlete to professional athlete? Because let's face it, not everybody's going to be drafted into the NBA. Not everybody's going to be playing at AAA Tacoma, Washington for the Mariners. Not everybody is an Olympian. That doesn't mean you're not a professional athlete. And I think that is really something that's sort of missing. And you see it in these emerging leagues. You know, say I do a lot of work with lacrosse leagues that are just starting up or soccer leagues that are just starting up. They don't have that bench and reputation to necessarily support these athletes who deserve a chance.
Yep.
Now, there are other visas within the law that have traditionally been used. It's not always about O1s and Ps. You can also use something called H-2B for seasonal workers. But that's an oversubscribed system with heavy regulatory components that at a decade or frankly 2 decades ago worked pretty well. That does not necessarily work so well today. So allowing OPT to potentially fill that gap is something that I think is ripe for advocacy.
Very good.
Agreed. I think that the issue that I see most often is student athletes who have just graduated who want to coach, right? Or who want to work as pros, like tennis or golf pros at clubs. And I want to be very clear that even on a P visa, coaching is not allowed. So you really, your first opportunity to coach is at the second rung of sports visas. It's going to be at the O. Unless you're a P1 support personnel and you're coming in as a coach in that capacity, a typical sports visa for an athlete who's doing a P is not going to encompass activities that would allow you to go on and coach. And what I see with OPT and the abuse of OPT very frequently is I see students who have just graduated. Typically, it's very common with golf and tennis for whatever reason. So then they get hired by a golf club or a tennis club to work there as a pro, but maybe they had a degree in marketing or they had a degree in, in accounting. And they're like, well, I do some office work, but I primarily coach. And I'm like, you can't get cover by calling it something that it's not, right? We need to understand what it is that you're actually doing. And if your duties are actually that you're out on the golf course, teaching people how to play golf, then, your marketing degree is not appropriate for that to be your OPT employment. And I see that very, very frequently. I don't know, Jonathan, if you've run into the same issue.
Oh, that honestly is one of my favorite topics of debate because there was some rule changes on it lately, but just because you're an extraordinary athlete doesn't mean you're an extraordinary coach.
Yep.
Like my favorite example, and sorry, MJ, but you might be the best basketball player of all time, but I don't know how well you're doing as an executive, homie. Like you gotta realize it.
Yeah.
You gotta realize it. You gotta own it. Now there was a court decision. Oh, when was that, Ksenia? I'm getting maybe 7 or 8 years ago now.
You talking about KSY?
Yeah, which essentially said if you can use your athletic prowess to show that you're an extraordinary coach, but it's really, really tricky when you're going to the pro setting. What that was really
narrow. The exception is that you had to have transitioned from being an athlete to being a coach relatively quickly, and you have to be coaching at least a national level.
Exactly.
So if you played NCAA and then you're suddenly coaching Little League, that's not going to work.
That's not going to fly. So that's more like, let's say you're an MLB player, and then you go to being a scout or a coach for a Major League Baseball club or AAA. There's an allowance there, but it doesn't cover people that are like Ksenia's example, where you're a great tennis player in college, and then you got this awesome gig to be a tennis pro at a really well-known country club. That doesn't mean it's going to lead to a visa.
Yeah.
And that's a tricky thing to navigate. I will say, though, on the team sports stuff, there are some advantages through something called the Compete Act, where people that might not have those super high credentials can get P visas just based on where the league is, and maybe that's a topic for a different day, but I think it does sufficiently show the complexity involved in some of these transitions, and that's more the point. Again, and I think if there's an overarching message from today's podcast and discussion is, if you're a foreign student, don't assume.
Mhm.
Don't assume that you can sell your name, image, and likeness. Don't assume that you can automatically take any job on OPT after graduation. Don't assume that just because your friends are moving into X, Y, and Z league that you're going to be able to do so. And if you start recognizing those issues now, while you're in school, freshman, sophomore, junior year, and you come up with a plan, then you are going to be better suited when you graduate. And Ksenia, one of the things I always say to people is, just because you don't meet the definition of extraordinary today, just because you don't meet the definition of professional athlete today, doesn't mean by looking at the standard, by looking at the enumerated qualifications, that you cannot make yourself extraordinary.
Right.
You can put
We
yourself
build
out there.
plans. We build action plans for athletes all the time. You know, I have people
100%.
check in with me and I tell them, not right now, but here's what you need to do. You know, when I have that action plan with somebody that may be transitioning from a student visa to a P, I have that action plan with people who are in a P who want to go to a green card. You know, and I tell them, look, I need a world championship medal, I need a continental championship medal, or I need you as a finalist in the Olympics. Once you have that, come back, let's talk. You know,
And sometimes it can be stuff you can control, like getting members of the sports media to interview you,
right.
to talk about your activities, to, frankly, in some instances, making your own prowess known by seeking rankings.
Mm-hmm.
You know, applying to different professional bodies, even if you're still like on the amateur rankings, or joining a national team in your home country in the off season. You know, there are these enumerated criteria which are attainable if you are pragmatic about it. Yeah, so, you know, I guess what Ksenia and I are kind of saying is that we're still operating within the traditional sphere of understanding the regulations as they stand today when we advise students, but we're very keen on the advocacy efforts that are coming up. And we're hoping that we can get to terra firma with some new regulations and guidelines that will allow us to expand the activities that I personally feel comfortable advising people to engage in.
Very good. Wow, what an insightful discussion. As we get ready to wrap up, I wanted to come back to Shahana and see if you have any kind of closing thoughts or any insights, or even any more questions, you know, that are kind of, you know, intriguing you at this point as we kind of close out our discussion.
Oh, you're on mute.
Thank you.
That's the best of us.
I think this is a really great discussion, and I think discussions like this and more so will be able to propel some change and make the waves that we want to make, and that is the goal. So to get the attention from the right people, I think No Cap Sports is reaching out to the right individuals and people in position to be able to make this change. And I think I'm glad we had this conversation to be able to move one step closer to being able to make it happen.
Very nice. Ksenia?
I just really want to make sure that as we sort of bring together our stakeholders in this effort for advocacy, we understand that, you know, there's a really patchworky kind of system in place right now. And I think that this really is an issue that requires the attention of the compliance officers at various schools. That this is something that in many cases, I think they're probably unaware of. And to the extent that they are, they don't know what to do with it. I spoke to a coach at my other alma mater, Berkeley, recently, and he was saying that, you know, the folks that he knows in compliance at various institutions have really been inconsistent about their position on NIL for foreign athletes. And as someone who himself is an immigrant, he really appreciates, you know, a more conservative take than some schools are taking. But, you know, what this demonstrates is that there are folks out there who may not be getting the best advice and who may be inadvertently putting themselves in jeopardy and putting their status and their immigration future in jeopardy. So this is an issue that I think deserves the attention of the compliance officers, of coaches who have foreign students, and of the foreign students themselves, so that we can create a landscape wherein it's predictable. Because, when we advise as attorneys, I know that good attorneys, as Jonathan said, are comfortable saying, I don't have an answer to this because one doesn't exist in the law. But, as people, that makes us uncomfortable because we want to be able to provide guidance to our clients that is helpful and that is actionable. And, right now in a patchwork landscape, that's really challenging. So, we struggle with these kind of unpredictable times and hope that we can sort of serve in a capacity to guide the conversation and to bring certain issues to light that may have not been brought to light previously, so that the relevant stakeholders can take it further, and a legislative advocacy effort can be put together with the identification of these issues in mind.
Absolutely. Thank you for your thoughts, Jonathan.
Wow, I love that, Ksenia. I thought that was really well said. Seriously. I guess I agree fully with those comments, and I do think advocacy is the key from all stakeholders. But I guess I would just like to reiterate sort of my plea to the student athletes that may be participating or listening to the podcast, and that you put a lot of effort and practice your entire life to training and becoming proficient in your particular sport, so that when you do act, it becomes almost like muscle memory, and you are a professional in your own right. And I think that that's what it comes to, like choosing the right counsel to guide you when you're in these situations. You want somebody who's dealt with these situations so that they have that almost memory to know like what to do in your particular situation. And when you're in this sort of uncharted territory where you're not really able to hold on to a particular regulation or hang your hat on a memo until that becomes solid, you want to be able to have that person who has had the experience with tons of other people before to say, here is what could happen. Just like when you plan out a game scenario and you're practicing for your competition. In a lot of ways, it's not that dissimilar. You research what your opponent's going to do. You have a game plan and you hope to execute it, but you want to go in with a game plan. Treat your immigration status with a game plan. Come up with your own strategy and try to execute it. Whilst not everybody is going to succeed in every single circumstance, and I always say there's no guarantees in immigration, you want to put yourself in the best position to succeed. And I think that is the essence of what we're trying to accomplish here today.
There you go. Well, I can't thank you guys enough for spending some time with us this afternoon and really educating us on this new landscape. I know I learned a lot. I'm sure our listeners did as well. And so on behalf of myself and No Cap Sports, just thank you so much for your time and your insights and your continued advocacy of what we're trying to do for student athletes that are well deserving of these opportunities that have come into play. So with that, my name is Will Baggett. Thank you for tuning into our webinar this evening, courtesy of No Cap Sports, and we'll see you next time.
Thank you. Bye.
Bye.